We know, sometimes we know how to make, sometimes we know how to grow, but we need to protect our assets. And we have great team here, attorneys group. You see, let's go back to the attorneys. See, you see, this is beautiful. This is Svetlana, Sokina, Michael, Kradi, right?
Karate Chop.
Yeah. And Stefania Park. They speak English, Spanish, Ukrainians. Yeah, so happy to have this. You know why they rented off? So happy we have here in our office. We feel very protected here because attorney here. Any letters give to this state. They take care for us. Because in real estate always we have lawsuit, always something. Now we feel good now because we have attorneys here. I wanna just invite. They're gonna teach us how to protect your assets, how to be protected, because we live in California. If you receive some lawsuit, people says, welcome to California. Yeah, welcome.
Thank you for that great introduction, Stefan, and I'm going to put my slides down. So yes, California is a very litigious state, so it's always good to know an attorney, at least so that you can, if you have a question, before you get to a problem, reach out. Once you get to the problem, reach out a little faster, but if you have the question, at least try to find someone within that field that can go ahead and help you and guide you. Okay, so here is what we will cover. Today, I'm speaking regarding the landlord-tenant relationships. So what does that cover? We help landlords with issues when they have rental properties, and mostly residential, but we also do commercial. Today we'll be speaking about residential because that is what most of our clients, that's what they have, that's what they encounter. So today we'll be talking about the screening process, lease insecurities, the rules during the tenancy, who needs to do what, and notices. Notices isn't just for when you're not getting paid. Notices are when there are different types of breaches or different types of situations that come up. Then we'll go into the eviction, unlawful detainer process. It's not very fun, but we need to know what we are standing against, or what the rules are, what the process is in order if we get to that point. And we will go ahead and finish with common mistakes. Okay, so before you rent, we are in California. We do have a lot of rules that protect tenants in this state. We have to be very, very smart about what we look at when we are thinking about renting our house or our property to a potential new tenant. There are, I like to think about it because I have my own properties that I rent out, and I like to actually meet the people. Because you get to know things beyond what the income, the credit score, the job history will tell you. And you can actually avoid a lot of issues just by talking to the person. Okay, so, if it's a guy renting, I have one situation where I have room rentals. So one of my very big pet peeves, and to keep harmony within the rental location, is guests. And you're renting to a single man. Okay, great. But then that single man in conversation tells you that he has a longtime girlfriend that lives, in San Francisco. Oh, okay, so she's gonna be staying here then, over the weekend or whenever. How many times a day or how many times a month, those things all add up, and they can potentially become little hurdles that you will have to overcome, with tenants and everyone making sure that they're getting along and things like that, or even things like parking. Parking is a very big issue in California. And if you have a studio and you're renting it to a single person, you're not expecting 2 or 3 cars to be in that same, being used by that same studio. So these are all things that are good to know. Also, whenever you are going to deny anybody, make sure that you document that denial. Don't just toss it to the side. Make sure that you keep that information. You have a folder in your computer labeled denials, and you put the name of the person and the date and the reason why. And the reason that becomes important down the road is because if somebody wants to come at you later on and say, well, this person was discriminating against me because I'm a woman, because I'm pregnant, because I have a dog, then you can go ahead and say, no, this person was denied for X, Y, and Z, not for any particular preference. Let me see. So I already went over fair housing rules, bars discrimination based on race, national origin, religion, sex, disability, familial status, and sources of income. So that means that you cannot discriminate against people who call you and have Section 8 vouchers. We have a couple of landlords who have a very strict no Section 8 policy. It's their personal preference. But when you get to having more than 4 units or 4 rental properties, you are now subject to the Fair Housing Act. So you cannot go ahead and make that distinction between tenants. And you have to be careful about the language that you use for advertising. You can't say no kids or perfect for singles, because that automatically creates an aura of discrimination. This is only good for certain type of people. Okay, and leases and security deposits. We want to make sure that we put everything in writing, because if it's not in writing, then it basically doesn't exist. You're a landlord, you're dealing with real property, which means that we are bound by the statute of frauds, which means that if it is not in writing, then it does not exist. You cannot use it if you want to come back and say, well, this person agreed to this amount, after the first year or after 6 months. It needs to be in writing. California recently tightened security deposit caps, meaning that we can only now charge, whether you rent furnished or unfurnished apartments, there used to be a difference. You could charge more of a deposit for a furnished location. You can no longer do that. It now has to be the same amount of the actual rent. There are a few exceptions. I believe if you are a small landlord and you own less than 2 properties and they are a total of less than 4 dwellings. But, make sure that you're checking what are the particular laws and restrictions that are pertinent to your particular situation. For itemized deductions, whenever the tenant moves out, make sure that you are honest. And because I do have someone that actually tried to, charge a $375 cleaning fee. That was not realistic. That was just something that that person came up with, and he wanted to charge that amount because he didn't want to give back the security deposit. Unfortunately, the security deposit is not yours. It is only there to cover for damages for whatever the tenant has left behind. That does not include actual regular wear and tear. This is an actual damage where someone put a TV up on the wall and they left huge holes, to hold up the 85-inch TV. That is something that you can use to repair and you can use the security deposit towards. But it has to be itemized. You have to give them a receipt and you have to give them the accounting and their refund back within 21 business days, or in 21 days of move out. And also make sure that you have all of your pertinent disclosures. Lead-based paint if the building is pre-1978, bed bugs, mold, in Sacramento, we have flood area disclosures, Megan's Law, things like that. Make sure that that's, included in your lease agreement. Okay, now, notice to enter. We generally have to give 24 hours written notice. Now, written can be interpreted very many ways nowadays. I have seen some landlords give text messages and they can go ahead and get away with that. It really depends on your tenant. I want to say just how electronically or technologically savvy they are is basically, the best way to go ahead and approach that. If it's a person that doesn't read text messages or they don't know how to access their text messages, don't send them a text message. Also probably not a smart idea to send them an email because they probably don't know their email address either. In that situation, you are better off mailing them something or posting it on the door if need be. Repairs and habitability. So we need to maintain the location habitable. What does that mean? That means that you have to provide running water. It has to be hot during the winter. There is actually no requirement just yet for providing AC, but it's sometimes depending on the unit and depending on the location. I have seen a few judges say that, okay, well, if this particular region, and I don't have that situation here in Sacramento, but there is one particular client that I helped in Palm Desert where the temperature is regularly over 100, then it was considered, the location was just extremely hot. But that was a very rare occurrence. And rent increases. Know how much you can go ahead and raise in any one particular year. It's usually no more than 10%. You cannot, if you're renting a location for a single studio for $2,000, you can't just turn around in 6 months and raise it to $2,750. You need to be cognizant of what the limit is per your county. Okay, so we are now to notices. This is the fun part because you can give notices. The one that most people know is the 3-day pay or quit if you're not getting paid. Obviously, if your rent is due by the 3rd and comes the 4th and you have not received your payment, then you want to go ahead and issue your 3-day pay or quit. So this gives it puts the tenant on notice that they have 3 days to pay any unpaid rent. And I specifically bolded that and italicized it and underlined it. Because at this point, sometimes as landlords, we can get a little bit angry and frustrated. And if it's not just rent that they haven't paid, if it's any other responsibilities that they have not paid, we want to include it in there, and we want to include fees. You cannot do that. If you go ahead and include those fees or whatever other those miscellaneous expenses are in the notice, then that notice is not going to stand up in court. You can only include the unpaid rent. And you have to give them 3 full days. That excludes weekends, holidays, before. You can't give them the notice on a Friday and expect them to pay you or to move out by Monday. That's not going to happen. And if Monday happens to be a holiday, then your actual time is not going to start until the next business day. So that would be Tuesday, and then they would have Tuesday, Wednesday, and Thursday, and you can go ahead and file your notice or your summons with the court, your package, unlawful detainer package with the court on Thursday. There are other notices, the 3-day cure or quit. So if someone is in violation of your lease, like they brought on, you realize that they have a dog and your lease says no dogs. Well, here you go, you have 3 days now to get rid of your dog. It's an unfortunate situation, but pets do cost a lot. They do cost a lot of wear and tear, additional than to what's anticipated. So if your property isn't meant for pets, then it's understandable that you will want them to get rid of the pet. And then there's the unconditional 3-day quit. This is for very serious violations, and it basically, you give this out when they have violated the lease and it's so egregious and it can't be fixed. I had one particular tenant who decided to, he lived in Santa Monica. He had a very beautiful rent control, amazing rent apartment, very close to the beach, and he decided to use it as an Airbnb whenever he was on vacation. His lease strictly said no subletting. Airbnb is technically subletting. So at that point he was given the 3-day quit notice, and he was trying to say that he'll fix it, but at that point it's already done, so you can't go back on that. And then there are your general 30-day notice to vacate. So if you, for just cause or whenever it's permissible, you can go ahead and terminate a tenancy by giving them either 30 days if they have lived in your property for less than a year, or 60 days if they have lived there for more than 2 years. This is the unlawful detainer process, or the eviction process. It consists of the notice. Once the notice has been effectuated, it's time to go ahead and file the UD. We serve the summons. You go ahead, you give the tenant time to respond. There's hearing before the judge, and then eventually when you have that nice little paper signed from the judge, we can go ahead and call the sheriff to do the lockout process. All in all, this process can take up to 6 months. So be careful who you rent to. Make sure that you check it out, that you check out people before you actually let them in, because getting them out is a lot harder than it seems. Also, once you are in a situation with a tenant where things are just not working out, do not escalate to self-help. And by that I mean changing the locks, turning off utilities, or just being a nuisance in any way, because that will just give them more credit and more power to stay. You can't retaliate, you can't charge deposits above the legal cap, you can't have inconsistent screening standards. Everybody has to be looked at and measured by the same standards. And sorry, you cannot, I've just been told that my time is up, so I'm trying to race through this now. Entering without proper notice, accepting partial rent. If you accept partial rent, then you cannot issue a 3-day pay or quit. You have to restart the entire process again. So, key takeaways: put everything in writing, apply your rules consistently, and use the court process for eviction. Don't try to do it yourself. And when in doubt, get advice. Thank you, everybody. I'm going to go ahead and pass this on to Lana, wherever she is, right over here.
Thanks so much. Wonderful. Thank you. Good. Good morning, everybody. Let me start by thanking Stefan, Agnes, and Mark for putting together business breakfast. Dennis as well. Everything is wonderful, and thank you all so much for coming here today. Really appreciate you, and we're very happy to share some very important information with you. So let me begin by telling you that I absolutely love doing estate planning. A lot of people underestimate the value of this topic, and they leave it up until it's too late. And today's presentation, I actually want to show you what's going to happen if you never get to do your estate plan. Meet our today's characters. This is their love family. Dmitry is 48, Anna is 44. They have 2 beautiful children, Alina and Maxim. They're both underage. In California, it means being younger than 18 years old. This portrait is taken in front of their wonderful family residence in Roseville. They're absolutely happy. They take this picture every year when kids get out of school for the summer. And guess what happened this year? This was their last year. Dmitry had a stroke and he never made it home. So what happened to his family? He left 2 underage children behind. No estate planning document. No trust, no will. And of course, probate has to be open. You probably heard the word probate. Everybody does in California. Everybody knows it's scary. I want to explain you how scary it is and why you should not end up there. Let's look at the Orlov's assets. So they own primary residence worth about $800,000. Actually, Dmitry inherited it from his parents, so it wasn't in his wife's name. It was his sole separate asset. They also had investment property, and as many men out here, he bought it in his name, being married. He took title as sole owner. He was a member of an LLC, owned 1/3 interest, had a small safe deposit box, about $15,000 in valuables, investment account, of course in Dmitry's name alone. His wife wasn't working. And he had some personal debt. As we all know, we live in California, right? Credit cards, bank loans, and of course some business loans with personal guarantee. So if you put together the numbers, it's gonna come to slightly over, not slightly, $2,370,000. Seems like a lot of money, right? But also don't forget about the debt that we have right here. And one thing people don't realize is when it comes to probate, unlike estate planning, you actually get to pay a percentage of what your estate is valued. So in this case, the family is going to inherit about $1.7 million because of the debts, right? But the probate fee is going to be calculated of this number. So the family is actually going to pay a lot more money because they're going to include the value of the mortgage, they're going to include debts. And let's put it in perspective. So the fee for probate for this particular estate, and in California it's an average client, right? There is a house, there is investment property, some money saved. A lot of young families, right? People living longer, people getting married later, a lot of people have underage children. The probate cost for this family is about $80,000. And let me break it down for you. You get your statutory attorney fees. Yes, in California, it's a statutory fee, meaning every attorney, unless you get some special deal, is gonna charge you the same amount of money. Because the wife was really upset with her husband's passing, she was depressed, she could not serve as executor. So they ended up hiring another person who also is entitled to statutory fee, meaning you cannot change it. So you're out of pocket $80,000, right? Because you're also going to have court fees, publication fees, you're going to have a lot more other things that come into probate. Just remember the number, right? 80,000. Guess what happens? Probate is the public process, unlike estate planning, where it's you and I who know what's in your estate plan. It's up to you to share it with whoever you want. I, as an attorney, keep it a secret. Nobody's gonna ask me, and even if they do, this is private. What happens with probate? The person passes away, probate is open, right? The first hearing is set. And everybody, when they come to my office, somewhere in a conversation, there is a question. So, Lana, will your revocable living trust protect me from creditors? And I answer honestly, no, it doesn't. Revocable living trust does not grant credit protection to trustors, people who set it up. But guess what happens in probate? You see this wonderful number out here, 4 months. In probate, there is a mandatory creditor notice that you have to serve, and your creditors, everybody who owed money in your life, have 4 months to file a creditor claim. And if they do it correctly, guess who gets money first? Creditors, not your family. What happens next? You notify your creditors that submit their claims. Partners will have to fight over how to take over your business because documents are not structured correctly. There will be a referee appraisal fee because they need to know how much the business is actually valued. Of course, they'll appraise the house, everything you owned. It's all public. It's all out there. Everybody knows what you own, what your family owns, who owns what, who gets what. Anybody can look it up. And of course, it's about another 4 to 6 months until you file petition for final distribution. It gets approved by the court, and that's when the wife gets the money. And the wife, as you know, she wasn't working, right? She was a home-staying mom. Guess what? Out of luck. None of the accounts are in her name, all in her husband's name. She has to survive for a year. Let's see what happens. Creditors lie. Everybody's trying to avoid them during life. Guess what? If you don't have a trust, they will find you after death. And their claims will be a lot stronger because they have those 4 months to get paid. And if they don't, the claim goes away. They're gonna fight. They're gonna fight in court. It's gonna be brutal. and your surviving spouse, your children will have to be part of it. What happened to this family? Unfortunately, they could not save the family residence because of the fight over creator fights, because the wife could not make money. She was really depressed, she couldn't work. They had to sell the family residence. And you can imagine, right, having your young children, picking up their everything they loved, moving to a new neighborhood, new kids, new friends, new school, how stressful that can be. And mind you, everything could have been avoided with proper estate planning. And what happens next is, as I mentioned at the beginning, the children are underage, right? What it means, if you give money in California to somebody who is under 18, it goes through probate. Again, probate, right? How wonderful that is. It goes through probate. The proceeding is called guardianship of the estate. And if both parents died, they're also going to be guardianship of the person. Well, in this case, because there was no will and no trust, money has to be divided between wife and children. The court is going to supervise kids' children up until they turn 18. Guess what happens when they turn 18? They get all of the money, right? 100, 200,000, $1 million. Now imagine in your head, 18-year-old with $1 million. How much good are they gonna do? Are they gonna buy a house, open a business, invest in their future? No. They're gonna buy cars, go travel, go shopping, potentially save orcas or some other animals, right? So you don't want minors to get into money, and court is not gonna sit on it more than 18 years. And these are just some of the issues that I'm going to cover today, because there are so many other things concerning title to real property, right? Concerning money, concerning guardianships. You have to be in court every 2 years, you have to do formal accounting, you have to spend money on CPAs, and you can't touch this money, even if you're starving. These are kids' money, and court is gonna sit on it. And the way it could have all been avoided is this wonderful binder, properly drafted estate planning, properly funded. The reason I add words properly is because you can Google, and there are a lot of people out there who can do estate plans for you. And all of them promise that for $500, they're gonna deliver the best product out there. That is not true. What happens to those people after they pass away? They come to my office, and I file court petitions, and I fight in court. And guess how much they pay me? My hourly fee. Pretty expensive. So what can happen with the estate plan, right? Probate could have been avoided completely. It's a very trust administration. After somebody passes away is a very, very discreet process. Nobody knows about it, creditors don't get notified. You're not gonna spend $80,000 unless your estate is worth $50 million, and trust me, there are very few people whose estate is worth $50 million. Your assets are frozen in court, as I mentioned, doesn't happen in trust. You get to be in family court potentially. Again, your properly done estate plan can avoid all of these issues. These are some of the court documents that an estate plan should include. As much as I say that there are things that are standard and in a way boilerplate, a lot of things are customized to a particular family, dynamic situation, second marriage, kids from prior marriages, somebody has special needs, somebody's getting divorced. All of these things can be addressed from proper planning and save you $80,000. So in case you don't want to end up in probate and spend a lot of money, you know where to find me, you know where to find another good practitioners who do estate planning. I just want to give you one advice. Estate plans are different. Don't buy into ChatGPT drafting for you. I've seen that. It has errors with it. Unless you want to end up in lawyer's office after somebody passes away, take care of your affairs now. Thank you.
I'm Michael Crotty. One of the things I came to mind while I was watching the landlord-tenant stuff earlier is something that may not be incredibly apparent, but if you have rental properties, the single most important thing you're going to be needing to do is hire an outside company to run your background checks. Right now, I'm in a holy war, which means 200 tenants against a single landlord. And there's a statute out there under Civ Code 1786.16 called ICRA, and ICRA stands for Investigative Consumer Reporting Agencies Act. It's a statutory $10,000 fine plus attorney's fees. You can't afford it if you don't follow all the formalities of running a background check. 3 days, within 3 days, you have to give them a checkbox. They get to request a report. You have to tell them what it's about, and all these wonderful 10 actual legal factors in the statute. So please, please, please pick a decent background check company if you have rental property. I'm dealing right now with cases that are running in the millions just in attorney's fees and statutory fees because they didn't have a professional company do it. And believe me, of the 7 or 10 factors, if you miss one by a day, or if you forget to do one perfectly, it's an automatic $10,000 fine plus attorney fees. So just going back to number 10. Mine is basically contracts, non-disclosures, and alter ego. I'm the guy that lives in court. You want somebody to go to war? I'm the one in the firm that can pick up on most of these things. I do a lot of civil litigation. I do a lot of holy wars. And the civil litigation is not just real estate. I do a lot of trade secret, trade skill, trademark, business formation, business assets, and things along those lines. We're going to deal with contracts, non-disclosures, and alter ego. Under contracts, number one, and I see this a lot, especially with people asking for help from here and other places, business name. People always put their own name on I'm purchasing the house, no, it's the corporation that you're running that's purchasing the house. So when you fill in the blanks, put in the corporation's name and put manager of or CEO of. The only time your name should ever be there is as the president or the CEO. You should never have your name in there. You're giving a personal guarantee if you are. You're guaranteed. Deposition in 10 minutes. You're giving a personal guarantee. You do not want to give personal guarantees. You want to use the business names. And then also, this one's a personal pet peeve of mine. Fill in the blanks. I know the computer software, I know the realtor software and everything else doesn't necessarily fill in all the blanks. But if you leave things completely blank, you don't put in not applicable or none, and you just leave it up for interpretation, there's two things that are a problem with that. One is, you may have missed a box. You may have not thought about it. You may have wanted to put information in there and it didn't. And the other is, you're not being completely clear with all the parties involved and all the judges and attorneys that are going to read it later about, did you really need to skip this? Is it really just a blank, or is it not applicable or none or anything else? This solves a lot of problems when you're sitting in court and have the documents in front of you. If you don't do it, and a lot of people who are filling out forms don't fill in every single blank, it becomes a problem, and this becomes an incredibly huge problem if you don't use standard forms. If you're just two guys with a handshake and you're buying a gas station and you've got a couple of blanks on a pre-printed form, they're on the back of a napkin, half done by Claude or Claude, this is incredibly important. It's less important when you're using car forms and RPAs and things like that, but I still like to see them filled in. But you will find that a lot of clients and people who are buying things on handshakes don't fill in the blanks, and it becomes an incredible problem for me. Realize that to overcome a blank, it's clear and convincing evidence, one of the highest standards in law. And so it's like, no, we actually meant the house 2 doors down on a different address. Well, everybody agrees, it's clear and convincing evidence, great, we're talking about the house 2 doors down. Otherwise, the contract stands. Non-disclosure. This is the holy war of real estate. And I've talked to a couple of people who are the flippers. So you have you have seller, flipper, buyer. You have normal seller and buyers. Whether you are the buyers arguing about the sellers not giving you a disclosure, or the sellers or the flippers not necessarily disclosing, this is the holy war. And everything that a realtor does is only about half of what's necessary to win this war about what is and is not disclosed. There is an incredible amount of information that's available that, especially when you're dealing with property, you're talking hundreds of thousands, millions of dollars, and people are going, okay, you got 10 days to do an inspection report, maybe you do, maybe you don't, sign off here. It's like, no, because it comes back that the plumbing is bad, the electricity is bad, the HVAC is bad. The two holy wars I've got going right now, one is plumbing and the other one is soils. Soils report, the soil around the property was moving, and it's in Marin County, and the house decided to slide down the mountain. Who's responsible for the soils report? Was there a soils report? All that wonderful stuff. And so, if you're going to do disclosures, and if you're going to use the RPA from car forms and things along those lines, what I want you to do is I want you to make sure that those disclosures are over-inclusive and go out of your way to look for things. You see cracks in the wall, guess what? The foundation's slipping. You do a walkthrough and you see boulders moving, or the backyard has got a fence the cement fence is a little bit off. Okay, guess what? The land is moving. You have your normal reports. You pull up a pest report and a couple other things. Go one step further. Everyone hates to do this as realtors and buyers and sellers. Go into the wall somewhere. Take a 1 foot section, look at the plumbing. Take a 1 foot section and look at the electrical. Something like that. Go above and beyond so that when you're buying it, you really know what you're buying as a buyer. And when you're selling it, you can say, I told you so, and we went beyond what we needed to do. We went even further, and we didn't find anything. And because a lot of people in the audience are going to rely on, well, we signed off on the contingencies on day 10, and therefore everything was, they had the opportunity, it was buyer beware, caveat emptor. No, that lands on my desk. We go to Holy War. We spend the next, I don't know, $50,000 to $100,000 arguing back and forth about plumbing. So be careful about non-disclosures. With the initial walkthrough, actually walking the property yourself, the history of the property, you are responsible for reports that you've never seen, buyer and seller, if they're in the public view. And so I got one where 2 buyers before they had the soils report, and the engineers filed it with the county and everything else. And the current seller did not tell the current buyer. Well, the current seller was responsible to tell them, even though they didn't have it in their hand, even though they didn't conduct the report. Go look at publicly available information on the property. Sometimes things pop up, and you're responsible to disclose it. And then on the non-disclosure side for the buyers, realistically, as a professional, professionals require something interesting. I define professional as it's mandatory, it does not exist, create it. And so in this particular case, create a new form that says, here's all the things we're disclosing, and it's above and beyond, and it's this, this, and this, and lock them into dates. You have until 10 days, 20 days, 100 days, until we lock you in, and after that, it's as is, it's your problem. To go the additional step, create the additional form, put everybody on notice that you've done your best, it might be something else, it's now your ball to either investigate or waive. Initials outside and inside, watch for soils and moving concrete retaining walls, look for supporting beams that have been cut, plumbing that's old. History of the property we just went through. It's tricky because some of the history is in other places. It is not on an MLS listing. It is not in the documents your client gives you to sell or buy the place. Got to take a look somewhere else as well. Pest inspection, structural, retrofitting, water conservation. There's lots of investigative expert reports. But I always recommend opening the wall somewhere and just take a look. Because most of my fights were bad plumbing, bad electricity, bad HVAC, and they could have been solved if somebody had opened the wall somewhere, rats got to it, the pipes are leaking, whatever it is. And at least one invasive report. Lock down the buyers, use hard dates, make sure what's going on. Alter ego. Business owners, all categories, not just real estate. There are 5 main areas about alter ego, about whether they can pierce the corporate veil. That's what we're talking about. How do we make sure that the business in piercing the corporate veil is successful or defended against? These are the 5 main areas, okay? But when you get into the lawsuits, one of the recent lawsuits in 2010, it's called Zoran. And it's basically 22 factors, and it's a totality of the circumstances. The totality of the circumstances is about all of the 22 factors, whether or not you're commingling funds, you're mixing up, or everything else. Piercing the corporate veil goes on both sides. Piercing the corporate veil as an alter ego is something that if you're a business owner or you're involved in real estate in a business aspect, you really need to start looking at the 22 factors. You can go down to 22 and knock off 3 of them and say, I fail, fail, fail. But 3 out of 22, totality of the circumstances, no, you really don't get to pierce the corporate veil. And so those are the aspects about issues with both landlord-tenant and real estate and piercing the corporate veil.
Thank you, Michael. Unfortunately, we have to let Michael Crowdy go. He actually has a very important deposition happening shortly out here, but both Stefania and I will be happy to answer any questions if you have them at this moment. And if not, our contact information is on the backs. You can reach out to us at any time, and we can talk to you one-on-one. Yes? Yes, bags are for people.
Yes. Feel free to take them.
Yes,
you guys.
please do. Yes, go ahead.
Are you guys sharing a copy of this presentation?
We could.
Yeah. You want to give you, let me give you the mic so everybody can hear you.
Okay. Question about landlord-tenant relationships. Is it applicable only for California estates, or like let's say if you have some rentals in other states, will they have some other requirements?
Yes, definitely. And you should consult with an attorney in that particular region so that, because they will know the particular rules, not just of that state, but that county, that section, anything that applies.
Okay. And about security deposit, something like, let's say the damages were really above the security deposit when tenant is leaving. What is the process to really get more to cover, or there is no way? If it's spelled in a contract, you kind of stuck with whatever they have to pay.
No, I mean, you can always go ahead and send them a bill. When you do the itemization, you will list line by line what you're repairing, how much it costs, the damage, and if it goes above the security deposit amount, then you send them a bill. The problem is then, how do you get paid? And depending on how much that is, then you're stuck in a situation where if they're not going to be, most people after they leave, they don't want anything to do with that, so they won't pay, and you're going to get stuck with a bill. And the only way for you to really get paid is to take them to small claims, because most of the time it's not $10,000 or more. So then you're stuck with small claims.
Thank you. Sorry. So as I see people start leaving, don't forget to bring bags. Okay, these are for you guys. Take them home, reuse them. Right? We live in California, reusable bags. Okay, you have a question, right?
Yes.
Of course.
I have a question. I did a legal eviction,
Okay.
okay? But I did not evict the tenant yet. How long is the eviction good for? She was a single mom with 3 kids.
Oh,
She
okay.
wanted to wait till school was out. I did the eviction, I let him stay. And now, how long, the eviction's been a couple months old now. Do I have to start the process over again, or is the eviction still good?
That is a great question. I mean, it's signed by the judge, so you can go ahead, technically you can start the process by sending it to the sheriff's department to get your date, because the sheriff is going to schedule your date, and it usually is a couple of weeks out.
Well, I called the sheriff's office and they said, hey, just call us the day of and we'll be out there.
Oh,
So, it's
Okay.
Riverside County, it's down by Palm Desert where you were.
Yes,
right?
yes, yes,
So-
yeah.
So the sheriff's office said, hey, yeah, we'll come, just let us know and we'll come that day.
oh, okay.
And I said, oh, okay.
Yeah, Sacramento, you have to send it, and it's like 2 to 3 weeks.
Okay.
That is a really great question. I would have to get back to you on that one. Go ahead and give your information to Paola, and she's right there in the back with the red pants, and we'll touch bases on that one.
And now I'm the only attorney left. They're both gone. So if you have any questions to me, I don't do as much landlord-tenant, but question to you, have you accepted rent after the notice?
No.
Okay, good. I think you are then in better shape than you could have been.
I have a question.
Yes, go ahead.
On estate planning. So, if it's a single business owner, a lawyer, does estate planning for a client, what happens to the case if lawyer dies and he has multiple cases estate planning for the client?
So typically, if we're talking about solo practitioner, right, it is on the attorney to prepare how to transfer the practice. So again, typically they would, usually if they've been practicing for long enough, right, they know good people around them, other attorneys that can buy their practice, right, or inherit their practice, however they reach the deal. Otherwise, they just reach out to the California bar and they basically surrender the client's information. Because I've been in a situation where we were hunting down trust created a long time ago, attorney retired and moved out, and it was really, really hard. Unfortunately, it does happen in real life, but it's up to the attorney to take those steps to protect the client's interest.
What would be my steps as a client? Where do I go if my lawyer dies?
Again, typically, your lawyer, knowing that they plan to retire, right, they would start unwinding their business and maybe introducing their clients to a new attorney. That didn't happen to you.
No, not if
Is it hypothetical or it's a situation that happened to somebody you know?
Yeah, it's just for my knowledge, for the future knowledge.
Oh, yeah, of course. So you would reach out to State Bar, California State Bar, and find out what happened to the attorney's practice. Also, obviously, keep your originals, right? Like attorneys keep copies. I always try to give all the originals to my clients. They take forever to pick them up, but that's the process. Keep your originals. That's what you need, because anyways, you will not be able to sell your house with copies, even if your attorney has them. If, let's say, your attorney disappeared, right? Got disbarred, died, something happened to the person. If you, let's say, if it's your trust, you can always restate it. If it's you and your spouse is around, again, you can restate it. If you got divorced, spouse passed away, might be more complicated, might require court involvement, but it's never a dead end. So even if something happens, there's always court, right? As a estate planning practitioner, my goal is to avoid it as much as I possibly can, but there are circumstances when it's unavoidable. So it's just easier to get things done when there is a trust, or there's the name of the trust. So we have a deed with that name, right? We have a copy. There are things we can do.
So it can be transferred to another lawyer, for example?
Yes, of course it can, and it happens quite frequently, especially with practitioners who actually plan to retire and they have enough time, right, to figure out where their practice goes. It's harder when they wait until they're really, really old and they just basically pass away without having a plan. At that point, you know, I don't envy their clients, but I've seen it go both ways.
Okay, thank you.
Of course.
Just to piggyback on this question, so is it okay to ask your lawyer, like, hey, what is your plan for your, when you will die? I don't know, you know, so every person should have, like you said, that typically they have a plan, so is it okay to ask them about what plan do you have? In case something happens to you, what will happen with my case?
You can discuss dead bodies buried in your backyard with your lawyer. I'm sure you can ask your lawyer about their plan. I wouldn't necessarily ask about death and other things because people tend to be sensitive, but it's only fair for you to find out what they're going to do, right? Especially if they are planning to retire and you know about it. Or let's say you can always go to another practitioner, right? And just transfer kind of your care there, because when it comes to estate planning, yes, it is a living trust. Yes, you have to update it. Yes, you have to review it. But there is no requirement that every single year you need to be in your attorney's office going over the trust. That is simply not true, right? But let's say your trust is 10 years old, right? It's good time for review. Go to another practitioner. Let them take a look at your trust, keep a copy of it, right? Transfer kind of your care moving forward. Because again, it's your best interest to protect yourself, right? Your lawyer can only do so much, but lawyers are also human beings. And things unfortunately happen to them, right? Because I never mentioned that guy Dimitri, was he a lawyer or not, right? Could have been. So things can happen to young practitioners, right? To all practitioners, but if you at least can predict that they're aging and they're about to retire, transfer your care. Take care of your own business. Don't just let it be and sit until the person disappears. Because again, I have, handled situations where we had to look for those trusts. And you can't always find them. And people leave states. And people go to mental hospitals, right? They lose capacity. That happens more and more. Again, trust is going to protect you from that. Not your practice, of course. It's a little different.
And what is happening with your trust if, let's say, you're leaving the country and you relocate to a different country, now it's your permanent residence?
Like country, like you're moving out of state.
Back to Belarus.
So let's say, for example, whatever property you acquired here, right? If you plan to keep it, you have your trust set up under the California law. If you move to Florida, you take your trust to restate it in Florida with Florida practitioner. If you move out of the country, right, and sell everything here in the States, your trust is no longer needed to be alive, right? You can just close it with IRS. But make sure that, let's say you move to another country, you move to Spain, right? Buy property there, live on the beach. Set up your estate planning documents in accordance with the law of that country.
I mean, what's happening with my estate here?
I mean, if you keep stuff here, right, and you have your trust, you name your trustee, who preferably is residing here in California, right? And when something happens to you, they can administer your trust.
What if nobody is here?
You can name professional fiduciary. It's a class of professionals who you can hire that are unrelated to you, right? But they're licensed professionals who are there in case you need to have executive for probate, in case you need to have trust, successor trustee, right? If you have nobody you can trust or no family around. So there's a class of professionals. And then you can always update it, right? Especially if you go back and forth between countries. But by you moving out, right? But you still having property here, just make sure your trust is in good shape. You know who your property goes to. And sometimes I have beneficiaries living all over the world, right? So dealt with somebody from Russia, dealt from somebody from Ukraine. So that happens as well because a lot of people move here, they have families abroad, right? So little things can be done. That's why you moving out of country does not invalidate your trust by any means. And there is no requirement for you to necessarily, live here and not live California for, I don't know, more than 6 months, let's say.
This is my last question for if your beneficiary lives in a different country, it's the same just type of trust? Or?
I mean, yes, it's just the trust administration will be different because of the tax obligation. I'm not a tax attorney, but when somebody lives overseas, right, they're entitled to money. It just gets a little bit more complicated, but they are going to get their share. So if they're entitled, and the case I'm describing with Russian beneficiaries was actually probate, and there was a fight over it, but she got her share. It took 2 years, but we made it happen. So yes, there is no problem with having beneficiaries out of state.
Thank you.
You're welcome. Go ahead.
A question regarding rentals. If a landlord has a no pets policy that was mentioned, but let's say you have a tenant that comes in with an emotional support animal, how do you, what options do you have can we confirm that that's true? Can we ask questions? How does that
Of course you can ask questions.
Or can you ask for
Please ask
documentation?
questions. And I would ask for certification. If it is an actual, I forgot what the actual word for it, but a service animal, then there is going to be documentation for that animal. I know, we live in California.
I was under the impression that you can't ask what, because it might be discriminatory if you ask questions or try to ask for supportive documentation.
I mean, I would do it I had actually a situation with a veteran, and he was trying to pass off a pit bull as an emotional support animal, and it's just, pit bulls are very friendly if you raise them correctly. But as a landlord, I wanted to make sure that, okay, you're a veteran. I'm not going to go ahead and assume. I asked him, where he adopted or when he adopted or when he acquired. And usually if it is an emotional support animal, well, I got him through the Wounded Warrior program, or, he was assigned to me through the VA or whatever other organization. But his answer to me was, oh, I adopted her at the pound 3 months ago. Yeah. I didn't have to ask for certification. That kind of already told me, this is not an emotional support animal, not a legitimate one.
And you can make your decision to not rent based on that, but that would be valid.
Looking at the totality of the circumstances, this particular person, his employment record was less than perfect and very unstable. So, no, I didn't cite the dog.
Just everything.
But, looking at the application as a whole, then I was able to go ahead and say, not comfortable with this person. Yeah. So I hope that answers your question.
And if a tenant, existing tenant, let's say they say now I have to have an emotional support animal, they bring an animal in, is there, because then you can't decline because they're already living there, right?
Yes.
Are there options to again verify or scrutinize that, ask for documentation, or you have to be careful with that?
I would be careful with that, but I also, like I said, there's more than one way of getting to the crux of the situation. Yes, I would be cautious about how you ask for it. But, you know, I also, I don't know if you do, I would recommend that you have insurance protecting you as a landlord. I have insurance protecting me as a landlord. I tell them, okay, well, what kind of breed is it? Because I have to check with my insurance to see if that's okay. You know, and that's how you can start the conversation. Don't come right out and ask it. Yeah. Sometimes you have to be a little bit sneaky, a little coy. Any other questions?
What's the name of the insurance which protects which I had similar situation? I had a rental for 2 years. Everything was perfect. They had a few dogs, and then one day, dogs bites the neighbor.
Ooh.
Yes, and the helicopter comes to pick up the neighbor. So they are filing against me.
You are joined in that lawsuit.
Yes,
Yes.
but praise God owns the trust. Massachusetts doesn't trust, so they cannot get a hold of me. But they know that I'm the manager trustee of the trust.
Yes.
So what in this situation when you say what protection every member?
Insurance would have been
I
able
even
to.
had terrorism insurance in my property. I had also insurance which protects me in case of the neighbor, it's the neighbor, kills the neighbor. Because I had another property, the neighbor was renting for 1 year and a half. And one day he comes and breaks down the neighbor's doors, with neighbors, and they get against him this same order. So I understand what you're doing.
Yeah.
I have, because you know, when you have one landlord, you have no surprise.
Yes.
This and you get different surprise. So when you say you kind of insurance protect the neighbor.
The landlord.
Yes, with the name. Because I tried to, what I did, I tried to research. I have like 7 insurances in the property, when I own a property, I have 7 insurances which protects it. So what are the insurance which I'm missing?
There is, I personally am insured through USAA, and they insure my rental properties, and there is a specific insurance that I have selected to protect me as a landlord. It protects me against, I think it's landlord protection. I don't remember what it's called exactly, but if slip and falls, things like that. The dog bite situation is actually in there as well.
But I'm out of that lawsuit. I'm out of that lawsuit.
Well, you are a very, very lucky man. Yeah.
It's a God's blessing.
Okay, and does anybody have any questions relating to, or directed for Michael? Because I can go ahead and swap out with him for about 15 minutes. Any takers? Any actual litigation questions? No, we're not there yet? Okay. Good, thank goodness. Any other questions at all?
So I have one, so it's like hanging ladies, couple of instances. Why do we just, I do have a couple of rental properties. So I used to play. I'll just tell AAA, give me A to Z coverage.
I would ask, I would let your agent know.
Yeah.
I'm renting, this property here, this property there, and how many units it is, the square footage, and ask them what kind of coverage do you foresee that I would need? And they'll be more than happy to tell you all of the different
I give them
options.
address and they already have everything on file.
Okay.
They
well,
cover my cars, they cover my house.
Rentals is a little different, but I just tell them, give me umbrella and all that stuff.
Okay, I would specifically ask, as a landlord, what kind of insurance policies do you have available to protect me?
That's it. Thank you.
Okay, last question?
Going once, going twice.
Okay.
No questions. Well, thank you so much, guys, again for coming. Thank you for organizing the event. We really appreciate all of you here.
Thank you very much. Special thanks for going the extra mile today. What do you think, folks? Did they cover it? Tremendous job. Thank you so much, ladies. We have oodles of things, food in the back before you leave. Please feel free to take it. The big screen behind us, we'd like to give a little recognition to that. It's been a joy, especially during the World Cup. Man, it showed real big. Arena Lux is the company behind this. We're blessed to have them join a part of the USKO family today. If I could have Alex Kravitz, and he's the CEO of the company. Give him a big hand. Football season's right around the corner, so I'm waiting for that.
Good morning to everyone. Thank you so much. To appreciate. We come here to serve you. So if any question about some big screen to your business or to your home, please don't shy. I can give to you any answers to this. Thank you so much. Have a nice day.
We'd like to extend the invitation out to anyone that's interested in getting into real estate to join our family. We're building an unbelievable team here at USKO Realty. We're proud to tell you that we are a very professional team with a lot of mentoring, a lot of hands-on, a lot of knowledge and assistance to make people successful. So if you want to get into real estate, see me afterwards. If you are in real estate and like to maybe switch offices, come see me afterwards. With that said, thank you, Stefan, for putting together a fine show. Big Agnes always has everything planned out perfectly and organized. Agnes in the back over here. One last thing, once again, there's plenty of food in the back. We thank you. If we make sure that we have your information, we have these meetings at least every 2 months, 3 months, and we'd love to have you back for those also. So thank you for attending. Thank you for sacrificing time. Have a great day, please.